Hi, everyone. Harry here to talk about Donald Trump's claim that he has total immunity for defaming E Jean Carroll, and therefore the second trial that's scheduled for January 15th shouldn't go forward. Wait a second, you might say. Hasn't this issue been bouncing around forever, and hasn't it already been decided? And the short answer is pretty much, but not quite. Okay, so let me start with where we are now and the news that just came down this morning. So the Second Circuit issued an order saying we've got the appeal from the case he already lost in front of us. We also have the appeal from the case that's going forward where he brought a motion to dismiss, and he lost that also in front of us. We're going to consolidate those two appeals. They both concern this issue or raise this issue of whether he was immune for the defamation. And we're going to decide that really quick because it came up in oral argument earlier this week that E Jean Carroll's lawyer said, we've got this scheduled now for January 15th. The former president has 4 criminal trials scheduled for the coming year. If we don't hold it now, it's never going to happen, or it'll be so long. E Jean Carroll will, her day in her justice will be delayed so much that it'll be denied. And the Second Circuit agreed. So it says, first, we're going to hear these appeals consolidated, and issued a very expedited schedule. So E Jean Carroll, well, actually Trump first because he lost, has a week or 15 days for his brief, and then 7, and then 2, much accelerated for what it normally is. And then it's clear they're going to make a holding on executive branch immunity so that if they hold against him, the trial can still go forward. If they hold for him, the trial might be scuttled. All right. So let's first, what is his claim? His claim is that when he first defamed her, and remember, this second trial is for the first defamation. The trial that already happened was for the second time he conveniently defamed her when he was no longer president. And that trial was also for the sexual assault in 1991 because New York passed a law permitting victims to do that. They had a 1-year period. Carroll took advantage of it. So that suit was for the second defamation after he's no longer president and the sexual assault. She wins. There's $5 million in damages. And moreover, the judge says, when we try this next one, this first defamation case, where it's already been decided that he defamed her, and so it'll just be about damages. Okay. His claim is for the first defamation. Remember, he's standing on the lawn and he's being asked about this by reporters, and he calls E Jean Carroll a liar. He says she's not my type. He's a total flaming jerk. And she says, you call me a liar and other things, you've defamed me. And his first effort was to say, it doesn't matter because I was acting as president here. That's the kind of thing that presidents do. They talk to reporters, impromptu conversations. They have, they have to respond to accusations, matters of public concern. That was just me doing what presidents do. And remember the stakes of that claim, because if the courts agreed with him, it would mean that the case would be actually against the U.S. government and not Donald Trump personally. And if it's against the U.S. government has sovereign immunity. It gets to decide what it is liable for, and an intentional tort like defamation doesn't count. So the whole case would go away. That's the stakes of his claim of executive branch immunity. All right, that's so. Second Circuit's going to decide it. That's first point. Second point, this is his argument. Third point is your spider sense is going off and saying, hasn't this been decided 18 different ways? Here's why you're thinking that, and it makes all the sense in the world. Remember, when she was first sued, the Department of Justice under Trump, Bill Barr, said, this is for acts as a president, therefore we want to come in and represent him, meaning the whole thing goes away. And somewhat controversially, when Merrick Garland became the Attorney General, this was one of the decisions he decided to stay the course on and not change. So the DOJ's official position in front of the court was, he's acting, he's got immunity, we represent him, he's off the hook. In fact, the whole case goes away. But that had to be decided by the courts. And it's taken this crazy route from court to court for literally all this time. It went to the Second Circuit that's now going to hear it, asked the D.C. court, the local D.C. court, what are your rules about when someone's acting within the scope of employment? Like a truck driver who hits someone, is he within the scope of employment for his business? Because that's what will inform us. And DC court basically said, we're not going to talk about that. It's very fact specific, etc. Don't ask us. And it went back, and then they remanded it back down to Kaplan, who officially has this issue of immunity and held against Trump. So while it's made the tour of some courts and Kaplan has said no immunity, it actually never went to the Second Circuit for a definitive ruling on it. And now we have, and it's presented in this second case coming up, because that's when he defames her as president. And he also made the same claim in the first case, but much, much weaker, because when he defames her, he was no longer president. His lawyer tried to say at oral argument, well, it still kind of follows from, it's sort of cloaked from the original defamation. All right, so point 3, this is how this issue that we thought had been decided. Oh, and I'm sorry, one more big point. After he defames her again, the Department of Justice takes another look and says, we're not going to say he was in the scope of employment anymore. One of the things they relied on is that he redid it, and they took a harder look. So they withdrew their argument in favor of Trump. So it was just Trump that was making it. Okay, but it's gotten beaten around, and it's taken a tour of the federal courts, but it's never been decisively disposed of, except by the current district court. So now it really is still alive for the Second Circuit to decide. Okay, so that's how it comes to be here, even though we thought that it's been running around for years, literally. Okay, so now the Second Circuit has the first defamation when he's on the lawn, and that's for the actual trial coming up. And they're also going to consolidate it with his much, much weaker claim for immunity from the second case that she's already won. I don't see that going anywhere, and so I think her verdict is safe and will survive. But if the Second Circuit holds that when he's on when he's president on the lawn answering reporters' questions, he does have immunity, if they agree with Trump, it basically will make the January trial go away. Probably. I'll give one final little asterisk, which is if they could remand it back down to Kaplan, who could say, all right, he had immunity at first, but since he did it again, that changes the profile. I think the Second Circuit will probably rule to that one way or another. So we'll know after they decide, and it'll be soon, probably end of October, mid-November, after fast briefing and oral argument. Did he way back when, in this first defamation, have executive branch immunity? So her defamation claim for that defamation is shielded, and she can't collect for it. and that would bring kind of this long saga to an end, where she would have been very successful in her lawsuit for the assault itself and the second defamation, but not for the first one when he was president. So we'll see what the Second Circuit says. It's still possible that this trial that is supposed to go in January will not, because of their ruling on immunity, which will be coming in pretty quick speed. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.